Good day, ladies and gentlemen, welcome back to another What If video. In today's video I will be discussing the use of cannabis by an employee outside the workplace. Now, as you are aware, in 2018 in the famous Prince matter, our constitutional court decriminalized the private use of cannabis. Now, from an employer point of view, the concern was what impact will the court case have on the workplace, and more specifically, does the court case now allow employees to smoke cannabis and report for duty? I hope that we can all agree that the answer to that question is no, because as is the case with alcohol, although the use thereof is legal, you cannot report for duty under the influence of alcohol. However, for me, an important consideration is the fact that in cases of alcohol, it is easier to determine whether a person is under the influence, whereas in cases of cannabis use, a person can use cannabis today and still test positive a few days later. Now, in such a case, if I smoke cannabis today and I test positive next week, it would be very difficult, if not impossible, for my employer to prove that I am under the influence of cannabis. Now, the case I want to unpack is a recent Labour Court matter between Enever versus Barloworld Equipment. And in this case, the court dealt with the issue of impairment versus testing positive for cannabis. In disciplinary codes that I have reviewed, most of them states a transgression of being under the influence of alcohol or being under the influence of cannabis or drugs. Now, that is important because the question is, do we need to prove in cases of cannabis that the person is indeed under the influence? Now, if you charge me with being under the influence, you would have to prove it. But what about charging a person for failing or testing positive for cannabis, or having traces of cannabis in your system? Is it still required to prove impairment? Is it still required to prove that the person is indeed under the influence? And this is what the case, amongst other things, looked at. Now, in terms of the facts, the employee was employed in an admin post, which was not safety sensitive or safety critical. She had a clean disciplinary record. Medically, she stated that for some time she had been suffering from severe migraines as well as anxiety, and this hampered her ability to sleep properly. Her doctor prescribed various pharmaceutical drugs to counter this problem. However, after the decision of the Constitutional Court in the Prince matter, which, as I said, legalized the private use of cannabis, she gradually reduced her use of pharmaceutical drugs and began to utilize cannabis oil, and she also smoked cannabis to remedy her medical condition. Interestingly enough, she also stated that she smoked cannabis for recreational purposes, so it's not only medical purposes. Barloworld, the employer, introduced an alcohol and substance abuse policy, and in terms of the policy, substance abuse was viewed by the employer as a health and safety issue, and the employer accordingly adopted a zero-tolerance approach to substance abuse. The policy required employees to be tested for alcohol and drug usage, and during January 2020, Mrs. Enever, the employee in question, was required to submit to such a test. She tested positive for cannabis, and she was then requested to vacate the premises for what they refer to as a cleansing period. She was asked to return to work after 7 days. So the cleansing period is a period of 7 days. She returned after this period. However, because she continued to utilize cannabis and cannabis oil, cannabis remained in her system, and her continued use eventually led to her being disciplined. She was called to a hearing, and at the disciplinary hearing, she pleaded guilty to the offense of testing positive for cannabis. So she was charged with testing positive for cannabis, which she pleaded guilty to. But she denied that the use had ever impaired her work performance, and she stated something along the lines that she was never stoned at work. She also argued that she utilized cannabis because of its medical benefits. Now, these arguments failed, and she was eventually dismissed for misconduct. She referred the dispute to the Labour Court. She claimed automatically unfair dismissal, and she also argued that her dismissal constituted unfair discrimination in terms of Section 6 of the Employment Equity Act. Now, the court rejected both claims. The court held that the employee's argument that she utilized cannabis for medical reasons was rejected on the basis that she had not raised this point during the disciplinary hearing and had also not provided any persuasive evidence to confirm her medical condition. this medical condition should have been confirmed through expert evidence. I think that's an important point for employers. The court also said that it didn't matter whether the employee utilized cannabis at work or at home. This is not a case where she smoked cannabis at work. She smoked it at home, but the court said that doesn't matter. Why? Because the employer, due to the highly dangerous operations conducted on its premises, was justified in adopting a zero tolerance approach. The court did point to the important fact that whilst alcohol is cleared from a person's bloodstream within a few hours, cannabis remains in the bloodstream for days after its use, the point I made earlier. And in terms of the issue of impairment, the court stated that proof of impairment was not required. For me, that's the most important part of the judgment. So the issue of, do we charge a person with being under the influence, or can we charge a person for testing positive? The court said that if you go to the testing positive route, we don't need proof of impairment, because this is a case that does not relate to performance or a performance issue, but it relates to a case of misconduct. And the court said the misconduct took the form of refusing to cease utilizing cannabis as required by the policy, and the court said that this requirement could be justified on the grounds of health and safety in the workplace. The court then held that the dismissal of the employee was fair. Now, ladies and gentlemen, I think that this judgment offers employers welcome guidance, and in terms that zero tolerance substance policies serve a rational and legitimate purpose, and you don't have to go and amend policies to address the use of cannabis by employees. Employees can be disciplined for breaching the provisions of such a policy. It must, however, be noted that the judgment does leave the door open for an employee who can demonstrate with proper medical evidence that he or she has a medical condition for which cannabis has been prescribed, to be reasonably accommodated in the workplace as a form of incapacity rather than being disciplined. We do, however, recommend that you at least review your policies to align with the evolving regulatory environment applicable to cannabis use. Ladies and gentlemen, that then brings us to the end of this video. I hope you find it useful. Should you have any questions on this topic, or should you require any assistance in terms of the review of your policies, please do not hesitate to contact us. I will see you in 2 weeks' time. Bye-bye.